The top takeaway for a lawyer working in disaster recovery legal services is to identify when an individual needs immigration legal assistance, when they need to be connected with an attorney, have a consultation with an attorney in order to stabilize their immigration status or help them obtain lawful immigration status here in the United States. So two of the main red flags that I would advise a lawyer to look into or to key into when they're speaking with a client, no matter in what area, whether it be foreclosure or issues with evictions, is to determine whether that person has family members who are U.S. citizens or lawful permanent residents, and whether those family members can help them apply for lawful status in the United States. So anybody with family members who are close relatives, such as parents, spouses, children, who have lawful immigration status should consult with an immigration attorney to see if there's anything that that family member can do to help them obtain lawful status here in the United States. If somebody's been the victim of domestic violence by a person in the United States, they should consult with an attorney who can help them obtain lawful status in the United States. Or if there's evidence of exploitation or abuse or threats in the workplace, it's possible that they could be trafficked here in the United States. And especially if they've been mistreated in any way, they should consult with an immigration attorney to see if there is a way to obtain stability, protection, and lawful status here in the United States. The skills that a lawyer needs in order to work with people who are in the disaster recovery world are skills that are transferable to all areas of law: immigration, civil, criminal law, which is just be patient, be persistent in getting the information that you need, and go into every situation without judgment or preconceived ideas in order to get the best information. Making the person comfortable that you're talking to will inevitably lead to good information, accurate information that will assist you in representing that client. Resources available to lawyers working in this field vary from state to state and city to city. The most common resources that people look to for immigration legal services is the American Immigration Lawyers Association, or AILA. There's statewide sections and citywide sections that are very active in representing individuals in immigration. Also, I would always look to nonprofit organizations doing the work in high volume. They usually have a very good sense of the community, what resources are available in that community, whether it be legal or social services for immigrants. And most of those resources are listed on the court website, the immigration court website, or you can find them online. And usually, if you do have contact with an AILA person, they'll direct you to the nonprofits in the community conducting those legal services.
So, some demographic information. For those of you who work in Houston, so this is the picture of the immigrant population in Houston. So just about 1 in 4 immigrants in the state, or maybe higher than that, live in Greater Houston. There are 1.4 million immigrants, defined as whoever that is foreign-born, not born in the United States, as immigrants. And Harris County has 80% of the immigrants in Greater Houston. And you look at the little chart on the right-hand side, sort of rank the immigrant population by county. Harris followed by Fort Bend, Montgomery County, Brazoria, and Galveston, and so on and so forth. So this is sort of like basic demographic information for you to kind of understand, there's very likely that you would encounter, even though you're not doing immigration work, you may encounter an immigrant family, a mixed status immigrant family, when you work with individuals or households affected by disaster. In the Houston area, it would be Harvey. In Florida, it would be, I don't even know which, Irma and Maria. And this is the picture for Florida. 4.1 million immigrants live in Florida. So 1 out of 5 of the state is immigrant. And about 850,000 of the immigrants are undocumented. Whenever we talk about the number of undocumented individuals, it's all a guesswork, right? They're undocumented by definition, cannot be verified, right? And then for households that have immigrants, so 1 in 4 immigrant households have mixed status, meaning that you have US-born children, US citizen, lawful permanent residents, but also undocumented immigrant household members. And Florida has the 3rd largest fastest growing immigrant population in the country after Texas. Texas has the fastest and California is 2nd. And Miami-Dade County, that cover where you are, kind of, yes? Yeah, so that is where a lot of the immigrants establish their homes. And then on the right side is where the immigrants are coming from. Cuba, by far, it has the largest proportion of immigrants, followed by Haiti, Mexico, Colombia, and Jamaica. So you do have a mix of immigrants from various countries there. So this is a brief kind of demographic background of the 2 regions that we cover. Any questions so far? So now, why don't they just get in line? Let's see how many ways you can get in line. So our immigration system since 1924 has been defined as, before 1924, there's no immigration system, so to speak. Anyone can come other than Asians that are completely barred from immigrating, starting in 1882 with the Chinese Exclusion Act and keep expanding to cover other Asian nationals. Until 1924, no Asians could immigrate to the United States. So there are basically 4 paths to immigrate to the United States: by family, employment, humanitarian basis, and luck. Luck is very narrow. So family. So parents, spouse, children, siblings. If you are a US citizen, you can petition for folks, your parents, your spouse, your children, and your siblings. And I'll talk more in detail in subsequent slides. So this is just an overview. Employment, who is eligible for employment immigration? You have to be a professional. Nobel Prize laureate would be better. You have to be a skilled worker, or you have a ton of money to invest. We're talking about $500,000 to $1 million. And then there's a special category. For some reason, got stuck in the employment category. Humanitarian, that is probably a very common issue that people may bring up. You can come in as refugee, or you can be here, apply for asylum, and become an asylee. Victims of crime, domestic violence, human trafficking could also be eligible for immigration status. Amnesty. When was the last time we have amnesty? 1986.
How many of you were alive in 1986? Just kidding. Inappropriate question.
So it's been at least a generation and a half ago when we have amnesty. And when 1986 we had the amnesty program, it was for people who can establish that they had been in the United States before January 1st, 1982. And with there was a major immigration reform in 1986 that provided for amnesty, but also a bunch of bad stuff that continue to haunt us as immigration system. Special law, that is if you can get your Congress person in your jurisdiction to file and pass a special law for a special someone, then you can also obtain immigration status. It used to be done in the 80s and 90s, but I haven't heard too many special laws since the early 90s. But it's theoretically possible. And luck would be something called diversity visa. You probably have heard about it in the news. This is the program that the current administration wants to remove. And we call it lottery because it really almost feels like a lottery. So going deeper into family-based immigration. So there are basically 2 categories of family-based immigration. One category is called immediate relatives. These are people who are the spouse, parent, unmarried, and under 21-year-old children of US citizens. They are immediate relatives, and therefore there is no quota for them. The US citizen can petition for those 3 categories of people, and the waiting time is really just the processing time. It used to be 8 months from the day you file application to the day that your spouse, children, and parent can come to the United States. Now it is 16 months to 2 years. Immediate is not so immediate anymore, but it's still better than the preference category. So under our family-based immigration system, we have a very interesting way of categorizing your relatives. Your spouse, your unmarried young children, and your parents are closer, rank higher in the hierarchy. Everybody else, a child that turns 21, not that close anymore. A child that is married, not close at all. And siblings. Siblings has always been the category that's been under discussion for elimination all the time, since 1980s. So the preference category, as you can see, unmarried sons and daughters are called preference 1, family-based preference 1. That's why it's called F1. Married sons and daughters are preference F3, and siblings are preference F4. Green card holder are what we call lawful permanent residents. So if you see LPR, that means they are the green card holders. These are the people who have lawful permanent residence who have not yet become US citizens. So they can still petition for some close relatives that include their spouse and children. When we talk about children under immigration law, is someone who is unmarried and under age 21. If you are married, even though you are 16, you are not children by definition under immigration law. Then you become sons and daughters. So preference F2B would be for unmarried sons and daughters that are, someone's children over 21 years old. Unmarried used to not have to mean never married. Used to mean that at the time the visa is available, you just need to be unmarried, which means that you can be divorced, but not anymore. So applications have been rejected for that reason. So we have 5 family-based preferences. 1, 3, and 4 are for US citizen petitioners. Preference 2 are for green card holder petitioners. So when you see a client who is undocumented, the first question that you want to ask is, do you have US citizen spouse, parent, child, or siblings who may be able to petition for you? Or if you don't have any US citizen, anybody close family members, do you have, what is the immigration status of your spouse? Is your spouse a green card holder? So that would give you a glimmer of hope that there may be a narrow path to apply for status.
Yeah, and when you're speaking with somebody and you're really just trying to see if there's any sort of issue that they can address with an immigration lawyer, I would even make it more broad. Do you have any family members who are residents or citizens of the United States? I would even ask about grandparents. You don't need to know the nitty-gritty of why grandparents might be important, but maybe the grandparent was a US citizen and applied for the mother, and that application is going to affect the person in front of you. So really keep those issue spotting questions very broad. In the family, I'm going to jump in here for just a second.
Yeah.
In the family petition context, there's 2 steps to the process. One is filing a form that establishes that relationship, right? So that's called an I-130, and that form basically you're just proving that you have the qualifying relationship. That's your son or daughter. That's easier, right? If you have a birth certificate and you're the mom, there's a lot of presumptions in your favor. But also the marriage, that the marriage is bona fide, right? If you have an 86-year-old man in your office with a 22-year-old wife, that step of establishing a bona fide relationship might be more challenging than, say, two 30-year-olds that have lived together for the last 10 years and just got married. So that's a two-step process. One is establishing the relationship, and then two is the adjustment of status to become a green card holder. That whole process can be really complicated depending on a lot of things: how they entered, how long they've been here, activities that have occurred since they've been here. But if they have a relative that's in these categories, that's an LPR citizen, definitely flag that for immigration, to at least have a consultation with an immigration lawyer.
Mm-hmm. Yeah, so the first step is get in line.
Right.
Getting in line, have a line to get in is crucial. So the screening part is really to figure out, is there a line for the person in front of you to get into? And then we can talk about the adjustment. It could be counselor processing and all those good stuff.
This is also in the news referred to as chain migration, right? So if there's some sort of legislation on immigration, this slide might look very different than it does right now. I think that eliminating the categories that are susceptible to be eliminated are siblings and
married children.
Married children.
Because siblings, you are grown up. Why does it matter? Your siblings are not that important anymore, right? If you're married children, you're on your own. You have your own household, so go, right? So that is kind of behind the mindset. There is a quota. The immediate relative side has no quota, but it's in the statute, so they have to really amend the law. Given Congress the way it is, it would be a miracle if anything meaningful could actually come out.
I mean, my opinion is, and my opinion is worth nothing, right? But every single person is affected by immigration, right? It's either, somebody has married a person from a foreign country. So I think that the immediate relatives is pretty sacred to most people. And I am hoping that that's never subjected to changes, but you never know. I think what's pretty popular among the legislators is the siblings and the married children.
I mean, what is actually interesting is that if you look at the current president, if the immediate relative category wasn't available, the First Lady may not have been able to immigrate.
So the Venezuela ban is very particular to a certain subset of to diplomats, but that's a really good question, right? So this is the law, and policy always affects what's happening on the ground. So the travel ban from those countries, I know that in our office we have a lot of clients from some of the countries listed on the travel ban, and there's various ways that that's been slowed down, but that absolutely affects the processing time and the ability to get people to the United States. It also depends on where that person is, if that person is still abroad or if that person's here in the United States. Yeah. But I can tell you that not only does a travel ban affect that, but the Department of State is actually doing, minimizing its staff, reducing its staff, and the processing times are just getting longer and longer and longer, so long that the numbers are just trickling in versus before.
Yeah. And that actually affect all categories of immigration in all countries, right? I mean, immigration is a very interesting legal animal, let's say. It's governed by statute, and then there's also regulation. But then all these, on paper may be good, may be orderly, but the implementation is based on agency policies, right? We have immigration court, we have immigration judges, but those are not real judges. They are administrative, they are part of the administrative branch. So the big boss over immigration is the Attorney General, right? We have a pretty active Attorney General, should I say, that has been affecting how immigration policies are being implemented on the ground. So,
and Any other questions?
Yeah.
This can be very interactive.
Yeah. And we try to stay on our neutral path.
Yeah.
We were instructed to do that, so we'll try to do that. So this is, let's get back to this neutral stuff. So this is a way to look at what we just talked about. So the blue thing, so the question to ask is, the person in front of you who may be the petitioner, is this person a US citizen? If yes, then this person can petition for the spouse, the parents, the children, and the siblings, right? And children further defined as, if they are under 21 years old and unmarried. Those are immediate relatives. There is no quota. Visa is theoretically always available. It's just a matter of processing time of up to 16 months to 2 years. But if you're over 21, even if you're unmarried, you get bumped to the preference category, even though you are the first preference. And if you're married, you get further bumped down to the third preference.
Also, immediate relatives can do that two-step process in one step, depending on several factors, but that's a huge benefit.
Yeah. And if the person in front of you is not a US citizen, then you want to ask, well, the other question is a person have a green card, is the person a lawful permanent resident? Then the person can petition for their spouse, for their children, and for the sons and daughters who are unmarried, who are over 21. So what about married children of a green card holder? If you are a green card holder, you cannot petition for your married children. Then what can happen? So you cannot petition for your married children. Can you petition for your siblings? Not yet. Can you petition for your parents? I need a babysitter so that I can work full time. No, sorry. So what do you have to do, right? Then a green card holder would have to hurry up and become a citizen so that you can petition for your married children, your parents, and your siblings.
So the green card holders can naturalize, and that is what Robert has been doing for the last 2 years, after a certain amount of time, 3, 4, or 5 years, depending on how they got their residency.
Yep.
So if somebody is in front of you and says, I've been here, and this actually happened a lot to me in Miami. We had a lot of Haitian and Cuban clients that had had their residency for 25 years, and you're like, why? Just become a citizen. So that's something that is very straightforward, well, depending on the activities that have happened since they've been in the United States, and it would be a good referral for an immigration legal service provider, too.
Yeah. And we'll cover that a little bit.
Oh, sorry.
No, it's fine. It's a logical question. What about boyfriends? Can I petition for my boyfriend, girlfriend? Right, so you at least have to have a ring. A ring is important. If that boyfriend, girlfriend never become your fiance, sorry, probably not the right person. I never encourage people to get married. What about grandparents? Well, sorry.
What about common law marriage? If you're in a common law marriage state?
Well, in Texas, it's a common law marriage state. You have to at least register. Right? You can be in a common law marriage forever, for 50 years. You still have to register, have a civil stamp on your relationship. Then the relationship is recognized for immigration purposes.
And depending on the jurisdiction, you can register retroactively, right? So you can get a certificate of marriage from 3 years ago before you had the child together.
Mm-hmm. Yeah, it is important how old is the marriage, because 1986, that gives amnesty, but also creates something called Immigration Marriage Fraud Amendment, assuming all young marriages are fraudulent. Young marriages are anything that's under 2 years. So in a common law marriage state, if you just register your 50-year-old relationship today, and you petition for your common law spouse, then you have to go through this conditional residence status, and then 2 years later have to justify and prove that it is still a good marriage. So it is important for those of you who may be doing family law, and there's like this immigration component in it, may want to consider what suggestions or what advice you can give to your client if the relationship has actually older than 2 years, retroactively registered.
And also, do we have family lawyers here? Because I would love to have like a family lawyer sharing my office with me sometimes. Do we? Is anybody here doing family law? No. Oh.
Yeah.
Because divorces, right? So you have to be married. It has to be a valid marriage. So sometimes people think that, for example, divorces or marriages in Haiti stayed in Haiti, right? You still have to divorce that person in order to have a valid marriage here in the United States. So that's often an issue.
Right. What about grandparents? You are a U.S. citizen, can you petition for your grandparents? I need a babysitter. Not yet, right? You have to petition your parents. Your parents can become U.S. citizen, then petition for their parents. It can happen. It just takes time. What about cousins? No? Yeah, so aunts and uncles is the same thing. These are one step removed. Our immigration, family-based immigration does not cover them until you kind of put in the middle person to do that. So, we have these kind of preference category. So let's look at visas. It's a matter of numbers, you know. If you have a visa, then you can become an immigrant. So like I said earlier, immediate relatives, there's no limit to how many visas are available. All the preferences have a ceiling. So for adult over 21 unmarried children of US citizens, we have 23,400 visas available every year for the whole world. And for spouse and unmarried younger than 21-year-old children of green card holder, we have a total number of 87,780 visas available every year for the whole world. For the unmarried older children of green card holder, it will be 26,200. And for married children of US citizens, we have 23,400, siblings 65,000. So altogether, this is about 220,000, 240,000 visas available every year for the whole world for family-based petition. And altogether, it's about 460,000 for all family-based immigration.
So question, for siblings, who knows how long the wait time is if you applied for a sibling and you're from Mexico? Right? We've got these loose immigration laws, right? How long is it? Yeah, they're processing 1998 petitions right now. So yep. You better be young and healthy.
A child, well, actually, a person has to be older than 21 years old to petition for anybody under the immigration process. So let's say when 19 years ago, and your sister happened to be from Mexico. 19 years ago, you filed a petition for your sister. At the time, she may be 20 years old. And in the meantime, while waiting for the visa, she got married, have kids. Finally, 20 years later, the visa is available. So the spouse and the children, if the children are still under 21 and unmarried, can come with your sister as a family unit. For Mexican nationals, this is very tricky, right? Because once you turn 21, you get dropped from that family unit. So you have to kind of hurry up, have the kid. The minute that you file the petition, well, you can. The math doesn't work, right? So for the sibling categories, Mexico is one, Philippines is another. By the time that the visa is available for your sibling, their children are probably over 21 and not be included. So here's another picture of, the number of visas. So there are two, big categories of visas. Family base is 480,000 every year for the whole world. And employment base, which I'll talk about later, is 140,000. Right? And on top of that, each country have a maximum number of total visas, whether it's family base or employment base, of a little over 25,000. So if you have a lot of people, let's say from Mexico, why does Mexico have a wait time longer than others? It's because you have a lot more petitions in the pipeline. And every year you only get 25,620. So once you are the 25,621, you have to move to the next year and keep pushing back, and that's how the backlog is developed.
So how you can check on these wait times, if you're just curious, obviously you don't need to do the math for somebody if you're doing a totally different type of law, is you can always Google something called the Visa Bulletin, and they come out every month, and it's usually a month ahead. So like right now we're in July, I think. And
July is out. August is not out yet.
It's not out yet,
Yeah.
so scratch that. You can do July 2018.
Yeah.
Pretty soon you'll be able to do August.
Mm-hmm.
If they already have a petition in their hand, you look at what's called their priority date, and you can see if their date is up and ready to be adjudicated.
So when people come to your office and they say, I think I filed something in 1997, don't take their word for it. Ask them for the receipt, official receipt that they received from the immigration. Back then it was INS, now it's USCIS. So that you can actually look at what is the priority date and verify. So this is the picture of visa backlog. We have 2,344,000 people waiting for a family-based immigrant visa around the world. As you can see, the sibling category, the F4, is the largest number of backlog. But everybody is waiting too. So Chiqui talked about the visa bulletin. It looks something like this, the chart. There are a lot of words, 3 pages of words before this that will explain, the visa allocation and the country limit. So, so we can look at, on first column is the different preference category. And the second column, very strange word, or chargeability. Meaning that a visa, so you have a bank of visa, and a national from your country would dip into the bank of visa. So that's called chargeability, I guess. I'm making it up. So these 4 countries that are specially put outside of the all chargeability are the countries that tend to have backlog, that they are processing later than the all chargeability. So, for example, preference F1 is for whom? It's for over 21 unmarried children of U.S. citizens. Preference 1, awesome, right? But they are working on application that's been filed on or before April 22nd, 2011. That is 7 years and a couple of months ago, right? But if you go to, so China, India is the same as the rest of the world, but if you look at Mexico, they're working on application filed August 1st, 1997. So when we ask people, why don't you become a citizen after 20 years? Maybe because they have an immigration petition pending. Actually, it's equally bad right now.
Yeah.
And Philippines they're working on June 1st, 2006. And if you look at, if you work at a lot of Mexican nationals, this is of particular interest, importance, I guess. Look at the preference 3 for married children of U.S. citizens. We are talking about, they are working on application file on or before December 1st, 1995. If these married children have children, there is no way that the children would be able to come with the parents in general. Right? And then if you look at a sibling category, preference 4, the rest of the world, we are talking about November 15, 2004, is 14 years. Every month it seems to stretch it a little longer. And if you are from the Philippines, we are talking about March 22nd, 1995. Mexico, January 15, 1998, is 10 and a half years wait. 20 and a half years. So this is, so this is public information that you can find on the Department of State. Type in Visa Bulletin, and you can find it. Pretty handy. Any questions so far?
One thing that I wanted to add is that the processing times, the most common, I think, complaint or question is, I filed something and I haven't heard anything, my lawyer hasn't told me anything. Processing times are increasing significantly. So for example, I'm going to pick on Robert because I can. He did citizenship cases, right, for 2 years. A year ago, how long did it take between filing of your naturalization application to the actual oath ceremony?
A year ago, 12 months.
Okay, 2 years ago.
6 to 8 months.
And now what is it?
18 to 21 months.
Yeah. So people are waiting 2 years.
It depends on the jurisdiction.
Right.
The local jurisdiction.
Exactly.
Houston is the law. That's almost.
So you could be waiting up to 2 years, or close to 2 years. So that's a common question, and it's a common concern, and rightfully so. Everybody has a neighbor that got their citizenship in 3 months, and that's just not happening anymore.
Right. Yeah. The other impediment is that all these petitions cost a lot of money. For naturalization application, how much is it? $760? $725? Yeah. So, you have to have the money to apply for citizenship.
And take a test and know the language, depending on how long you've been here. So.
Yep. So that is the family baseline. You're lucky, you get in line, you wait. At least you can wait, right? So I don't have any. I only have a cousin who is U.S. citizen. So I'm hoping that I can squeeze into a line based on employment. Everything is preference-based. So under employment, there are 5 preference-based categories. So like I said, preference 1, top priority. These are for really practically genius, Nobel Prize laureates, or PhD. They have to be extraordinarily recognized in science, arts, education, and whatnot, or outstanding researchers, professionals. So more people are likely to be eligible under preference 2. These are people who have a master's degree or with exceptional ability in the art, science, and all that good stuff. Preference 3 would be for individuals that have a bachelor's degree, right, or skilled workers. And then preference 4 is really not employment-based. It's just stuck there as the miscellaneous. That include, for example, we work with unaccompanied children. So if we can help them get special immigrant juvenile status, they will be stuck in preference 4. And also the SIV, the special immigrant visa, these are individuals from Iran, Iraq, Afghanistan, also under preference 4. And preference 5, so I'm not a Nobel Prize laureate. I don't have a master's degree. I don't even have a bachelor's degree. And I am not a special immigrant juvenile. And I'm not a special immigrant visa holder from Iraq or Iran. But I have money. How much money? Well, at least $500,000 to finance a new commercial enterprise that would create 10 permanent jobs, not for your family members, 10 permanent jobs for the workforce. Then you and some of your close, immediate relative family members can get an immigrant visa. There are wealthy people like that, too. So you may want to ask your clients, any way you can put together $500,000 that would help you squeeze into this line.
So just as a side note, I can speak for the YMCA, and I think Catholic Charities pretty confidently that we don't do employment-based immigration. So if you have somebody that you think needs a consultation related to employment visas, that would be a different set of attorneys, and we can get you that information as well.
So, and then some of the employment-based category would require, this labor certification requirement. That is, that the employer has to promise that this position will pay prevailing wages and is set by the Department of Labor based on the job category and the location of the job. And that there's no non-immigrant workers qualified for the job. So they actually have to put an ad out in select newspaper. I am not too familiar with this. It's been 30 years since I've been touching this area. So if
Just
anyone
aged yourself.
I started young. So if anyone comes in with employment-based immigration issue, refer them out. They have money and could afford a lawyer. So I don't have close family members, and I don't have, employable skills or money. So let's say if I can fit into this humanitarian-based immigration. So the first category would be refugee or asylee. So what is the difference? Robert?
Let's see, whoa. Let's see if anybody knows. Does anybody know the difference between a refugee and asylee?
Yeah, it's up there.
Well, who can read slides and wants to raise their hand?
Yeah. Yeah, so refugee is pre-approved by UNHCR, a lot of times from a refugee camp. So by the time they came to the United States, they already have the refugee status attached to them. Whereas asylee, you could be, seeking asylum at the point of entry, or you apply for asylum after you come in within a year to apply for asylum. And just bringing back to the current affairs, so a lot of the separated families, they were asylum seekers. They asked for protection at the border. Some of them were not at the port of entry, and therefore, they get intercepted by Customs and Border Protection and detained.
You want me to?
Yes.
So this is really the fun stuff, right? Asylees, or asylum law and refugee law, I think is really interesting. You're not going to probably encounter somebody that's seeking refugee status, because we all work in the United States and they're seeking refugee status from outside the country. However, if you do see a refugee, there are still steps that they can take and benefits that they can obtain. So if somebody enters the United States as a refugee, after 1 year, they can apply for adjustment of status to become a lawful permanent resident, so a green card holder. They're also eligible for benefits for a certain amount of time, and I think that that's probably where your field will intersect with our field. A lot of times people, especially if they're missing documentation or they can't prove certain things, need help obtaining those benefits, cash assistance, Medicaid, and other things. So what is asylum? Let's talk about asylum, because that's really pretty fascinating. Asylum is for people who have been persecuted in the past or have a well-founded fear of future persecution on account of one of 5 protected grounds. Okay, those grounds are race, religion, nationality, political opinion, and membership in a particular social group. So if somebody comes to your office and says, I'm afraid to return to Venezuela because I worked as a leader of a political group that was very vocal and active against our current president, and he started attacking me, sending people to threaten me, and I finally fled my country. Do you think that person would be eligible for asylum, or just worth speaking to an immigration attorney? Yes. Okay, so we say yes. Why? Have they been persecuted in the past, or do they have a well-founded fear of future persecution? Okay, both. What is persecution? So this is like a 3-hour, 4-hour presentation that's going to be condensed into about 5 minutes. But so there's lots of nuances, right? And the books are really big and large, and it's kind of complicated. But he was persecuted in the past. So let's say that you've got past persecution and what he experienced, right? We just know the general details. That he's been persecuted in the past, so that creates this rebuttable presumption of future persecution, a well-founded fear of future persecution. So the real sticking point, well, after new case law, which we can talk about in a second, the real sticking point is the nexus. Why? Why was he persecuted? Why did the authorities go after him? Why did the government go after him? That nexus in 99% of cases is the most difficult part to prove of an asylum case. What do you think is the nexus here? What is the protected ground? What was the motivation of the persecutor? His political opinion, exactly, right? So that would be my argument without knowing more information. So he was being targeted and threatened by the government for his political opinion, right? His opposition to the government. And there's a lot of issues that would have to be fleshed out, but that's generally asylum law. So you have to seek asylum. You have to file an application within 1 year of filing or of entering to the United States. What if you, the same person, let's say, came to the United States, got hit by a car 10 months into his stay, was in the hospital for 6 months, and he's now out and wants to seek asylum? Are there any exceptions to the 1 year filing deadline? There are exceptions to the 1 year filing deadline. Exceptional circumstances and changed circumstances. An example of changed circumstances, for example, would be a governmental change or a regime change in that home country that now is targeting that person, people like that person in the home country. So there are exceptions to the 1 year filing deadline, but generally you have to apply for asylum within 1 year. So I'm going to take a step back for a second. Is this where you thought I was going to go?
Yeah.
Yeah? Okay. So
This is the unpracticed together orchestra part.
So there's 2 types of cases. We just talked about family immigration. Family immigration is about people going to immigration and seeking a benefit, right? Going to an agency and seeking a benefit. So generally, there's 2 types of cases. There's affirmative cases and there's defensive cases. So if somebody is going seeking a benefit, they're seeking a benefit affirmatively. They're going to USCIS or DHS for that benefit. And that's true for both, for asylum as well and humanitarian relief. There's also the defensive. The defensive process is when you have been apprehended or encountered by immigration officials and put into a process. So this is taking a big step back, right? But if you are encountered, let's say you enter the United States, 2 things are happening a lot lately. One is you're entering at the border and you're being apprehended at the border, right, between ports of entry, and you are being detained by ICE, and we've all read the news, and it's on NPR every 3 minutes. They're detaining you, and you're being put into this process. The immigration law is very simple in that context. You've entered the United States, you've entered without a valid permit or visa, and you're in violation of the immigration laws. So they put a charging document into the courts, and now you're in a court setting, a defensive setting, where you are one side and ICE is another side. And there's an ICE officer or attorney that is trying to deport you or remove you, right? And there's an immigration judge that adjudicates the case. That's defensive. Which position would you rather be in if you were trying to seek asylum? There's a huge difference that I haven't even mentioned. But I think most people will agree that the adversarial system of that defensive process is the least desirable place that you want to be, right? Going affirmatively, you're putting yourself into a system, and there's an officer listening to your case, reviewing your evidence, listening to the testimony, and deciding your case. It's not adversarial. So if you have a person coming to your office that's talking about an asylum case, like they're afraid to return to Guatemala because the gangs there started charging him rent, and he's afraid that since he can't pay, that they'll come and attack him and his family. What would be the first question you would ask? When did you come? Have you ever been apprehended? Right? The sense of urgency, well, depending on when they came, differs greatly on if they're in the affirmative process or they're in the defensive process. If you're in the defensive process, and depending on where, Florida moves much more quickly than Houston, then they will have hearings coming up, and they will have to defend themselves against deportation. One of those defenses, right, I told you very simply the violation is entering without permission. One of those defenses is asylum. So they can seek that defense in court, but they can also affirmatively go to the asylum office, which is the non-adversarial system seeking asylum. The issue with affirmative cases is once you've presented yourself to immigration, if you don't win your case, what do you think happens? You get put in that defensive process. They say, okay, we know you're here. We know that you're seeking asylum. You didn't win at this level. We're going to issue that charging document to the court, and then you're going to be in that defensive process, defending yourself against deportation. So asylum is available to anybody that fears returning to their home country. It's a free application, but you have to prove some very, very, very difficult requirements. And we're not talking about AB right now, or no?
You can jump into AB.
Okay. So
and Pastor Tom.
Okay. So each of these requirements, it looks so simple and friendly, right? But it's actually kind of complicated. The asylum, most of the people seeking asylum in the defensive process and many of the affirmative process, or most of the people entering seeking assistance, fall under this fifth category, membership in a particular social group, right? So what does that mean? If somebody says, the Guatemalan example that I gave you, does everybody remember it? So, right, so it's a social group. There's characteristics that have been defined by case law from a long time ago. One of those is that it has to be an immutable characteristic that they were trying to overcome, right? It's really hard to define a particular social group. And there's lots of case law that's come out since the number one case, which is Matter of Acosta, defining particular social group, that's tried to define and redefine the requirements for establishing that you are a member of a particular social group. But one amazing case that came out in 2014 was Matter of ARCG. And that was a case where since 2000, I think, advocates have been fighting through two other cases for establishing that domestic violence victims are part of a particular social group. That people who are in partnerships where the partner is abusing them and they're unable to leave, and the government is unable and unwilling to protect that person, they don't respond to police reports or calls to the police, that they're a member of a particular social group. And that was a very significant case because it established that if you can show that you were in an abusive relationship like that, and the government was unable or unwilling to protect you, that you qualify for asylum. Obviously, it wasn't as simple as that, but at least there was case law protecting that group of people. It often extended to children, right? Children who are in abusive custodial relationships. So step-parent, parent, grandparent, whoever was taking care of the child was incredibly abusive because the same power dynamics applied. Last month,
exactly a month ago. Yes.
Exactly a month ago today? Mm-hmm. Well, let me take a step back. The Attorney General has this power or ability to take established case law from our appellate courts and
From the BIA. Only from the BIA.
Right, from the BIA, the Immigration Appeals Court, which is the Board of Immigration Appeals, and review, I guess, the decision in that case. So he took a DV case called Matter of AB and asked for a briefing on it in February, and decided the case differently and established binding case law on all immigration courts that victims of domestic violence, generally speaking, do not satisfy the elements for a particular social group. That private actors, such as abusive husbands, are not the appropriate persecutor. They have to show a much higher bar, that the government was either, I can't remember the exact language, acquiescing or assisting in condoning the behavior by the abusive partner. So I don't know how that's going to be applied, but the case law surrounding asylum, surrounding victims of domestic violence, which after working for years with people arriving to the United States, I can tell you that that and gang violence are two of the most commonly seen cases for asylum and reasons for fleeing these countries, especially in Central America.
Right.
So that's problematic and scary.
Yeah, and it's really devastating for us that represent unaccompanied children. Particular social group based on child abuse, domestic violence, or death threats from gangs or murder of family members has been the basis of a lot of our asylum claims. So with Matter of AB, we have to really rethink what is the path to asylum. For young children, it's very hard to establish that they have a political opinion. So we have to, for Guatemalans, we may have to increasingly look at their status of being indigenous people. So, we are still working to rethink our strategy, basically. Yeah.
Yes, actually yesterday the Third Circuit came out with a decision that was basically affirming the AG's decision.
Oh.
But so that question is the number one question that I've been asked and I looked into. There is an appellate process. That wasn't a case that came out yesterday that was AB. The decision is appealable. It has to be appealed in the circuit that it came from, I believe. And I don't know exactly what, I think we looked it up actually, what the process is, but I think it's a long process. So gender-based violence is something that I would encourage attorneys to argue, but it's not a very easy case to win, right? Because there's so much case law around particular social group. It can't be too big, it can't be too small, it can't be too, particular, it has to be particular enough. And one judge in an opinion said, I think asylum is very easily defined by people fleeing Germany during the time of Holocaust, right? If there were too many Jewish people that were being put in concentration camps, is that not asylum because it's too many? I think that we would argue that, no, that's still asylum, even though the group is too big. But the case law as it stands right now says that a group cannot be too amorphous, too not easily defined, or too large, too broad. So gender-based violence, it would have to be gender plus something, right? Yeah. And to narrow it down. Otherwise, 50% of that country's population could flee that country, and it wouldn't be a particularized harm.
Right. So let's wrap up the asylum, and then we can go to the victims-based immigration issue. I want to follow up the issue that you brought up, because the AG's opinion in Matter of AB talk about the government's role has to be more like condoning. So the statutory framework of the home country may be relevant in that respect to overcome that burden.
As a side note, what I find problematic is many of these countries do have laws on the books, but they're not enforced, and they are doing nothing to ensure that they're eradicating the issues of domestic violence. And I think that before it was already a challenge to show that the government was not able or willing to protect that person, and now it's going to be even more of a problem.
Yeah.
So let's keep going. I love your enthusiasm for asylum law. I knew that you were at Tahrir. I thought that.
So the question about, I don't know why that's so, so VAWA. So Violence Against Women's Act was passed in 1994 that would allow victims of domestic violence to self-petition for immigration status. So since the 1986 immigration reform that create like conditional status for spouse of a young marriage, so domestic violence has been used by the spouse that has citizenship or ability to confer immigration status as a tool to perpetrate domestic violence. So VAWA happened after years of advocacy, right, to provide a way out for a victim of domestic violence to get in a line without help of the abuser. So
So what's a typical fact pattern?
typical fact pattern. So fiancé, someone came into the country as a fiancé. You have 90 days to get married. So they did get married within the 90 days, except that and only U.S. citizen can petition for fiancé. Green card holder cannot, right? So the U.S. citizen spouse keep not filing the immigration petition, dangling it over, you have to cook dinner at 6:15. I want it hot. I wanted this. I wanted that. So that's like a typical kind of scenario that I've encountered, right?
Or
so,
abusive, saying not to call the police. If
Right.
you call the police, I won't,
Yeah.
file your papers.
Or you are not allowed to go out without my permission. I'm going to spy on your cell phone all the time. You have to give me your cell phone. So all different kinds of kind of abuse that you can imagine. Never filed for petition, and one very violent, abusive incident happened. Finally, the immigrant spouse had to leave to protect her life or the children's life. So came to your office, have this history of long abuse, and once you want to ask, what is the immigration status of the spouse? And if you find out that the spouse is a U.S. citizen, are they lawfully married? Is marriage in good faith, bona fide? Bona fide doesn't have to be based on love. All it needs to be is that it's not solely for immigration purpose. So it's important to recognize that. And then you can help the person file the petition on her own without the help of the abusive spouse, as long as they are not divorced for longer than 2 years, right? And that could include the children. And children who suffer domestic violence can also petition for immigration status by themselves. Bless you. So if back to the same scenario, fiancé never got married. So there is no bona fide marriage to support a VAWA. So the U visa was created in response to cover the category of victims of domestic violence that are not in a marriage. And it got expanded to cover 33 different qualifying crimes. So if you are a victim of one of these qualifying crimes and you cooperate with law enforcement investigation or prosecution of the crime and get a certification from the law enforcement, you can apply for a U visa. Except that U visa is not a green card, not right away. It's a non-immigrant status, and after 3 years, you can adjust your status to get a green card. T visa would be, is for victims of human trafficking. Severe form of human trafficking could be for sex or labor. Again, they also have a requirement if they cooperate with law enforcement investigation or prosecution, then they can apply for a T visa. For T visa applicant, they do not need certification from law enforcement. The only catch is there are only 10,000 visas available for T visa or U visa, 10,000 each every year. T visa is never used up. They're always left over of 7,000, 6,000 visa. U visa is used up very quickly, and I think the backlog now is like 7 years?
4 years.
4 years? Only 4 years? Okay. So 40,000 people waiting for a U visa. Something like that. Right. So because every year there are only 10,000, then there are more applicants than visas available, so they kind of wait in limbo. They get something called deferred action, but I know that the process has also been lengthened significantly. Deferred action would allow someone to have a work authorization so that they can lawfully work.
I think there's a lot of factors, but I don't think it's them fighting against the T visa. The T's, U's, and VAWAs go to a service center, the same place, and they have had extensive training on victims and survivors of domestic violence and trafficking, and I think that they are pretty fair. The issue is identifying trafficking victims and having them come forward.
And that's what I was
Yeah.
That's what I was really going after, is it because they were afraid to come forward. But you just hear really horrendous stories about what their fears are, what's happened to them. And I mean, personally, I think I'd be scared to cooperate. If it meant I got to stay. I mean, I don't know what you do.
Yeah.
And that's what I'm wondering, is like how that cooperation thing is tough.
It is. One thing that I wanted to mention that I think will be relevant in the practice that we're doing here is there's a lot of people that don't identify as being victims of trafficking because it's not the typical sex trafficking case. So we've had, when I was at Catholic Charities, 2 cases of kids that got a certification from the Department of Labor. I'll explain one, and it's a good example of exploitation in the workplace. This kid came to the United States, was detained in an ORR shelter, released to an uncle, and the uncle and aunt arranged for the kid to get a job at Jack in the Box. And he started working extensive hours, and they were, the uncle and aunt were saying, this is something that you need to do in order for us to take care of you and stay at our house. And so he was not involved at all in getting the job or the paperwork. They had put a false name and identification attached to him, and the name was the name of the uncle. So the checks from the fast food chain went straight to the uncle. The uncle cashed him. He never saw a dime. He was working over 40 hours a week, wasn't able to go to school. That's just an example of exploiting a child, right, in the context of a job. And that is much more difficult to identify. You have to be good at screening. And that's also, that child, I think, has a pending T visa. I don't know what the result was. But they got the certification, which was the most difficult part from the Department of Labor. So common questions to ask are, have you ever been mistreated at work, threatened at work? Did anybody take your identity documents? We've had clients that are literally unable to leave the situation they're in because they're holding all of their identity documents hostage. Those are huge red flags. And certain industries are more prone to exploitation than others as well.
Domestic workers is a very common form of exploitation, human trafficking. Asking the question, where are your documents is kind of like a red flag if they don't have the documents, and you want to ask who has your documents. Did you ever have your documents? So that is the beginning of the screening process. And domestic workers are very hard to reach because by nature of their work, they're always attached to the family, and the family oftentimes have a lot of control about how the contact with the outside world.
So a plug for EJW, I'm sure they appreciate this. We have a EJW fellow that just started at the same time, and there are several in Houston. Do you guys have one?
Crime victim?
Yes.
Yes.
That does exclusively trafficking work. So if you do work in Houston, and I believe there are fellows in Florida. There's just so many resources for survivors of human trafficking, but there's really sort of full service agencies, ours being one, Catholic Charities being another, that provide social services and legal services and housing and medical and everything for people who have survived human trafficking.
Yeah. So the point of this training clearly is not turn you into expert at the end of the training, but just to give you some framework to identify issues with the people that are in front of you and connect with the rest of your fellows and the providers in your area to connect your clients with them. So I think we are, sorry, go ahead.
Is it common for persons with a T visa and a U visa to remarry, and does that complicate their status, or how does that work?
No, they can oftentimes include their children and spouse as derivative U and T visas.
But the marriage doesn't affect the U and the T because they're petitioning because of what happened to them if they're the principal applicant, right? One of the things about the U visa and the T visa that's a big flag is they once they get that visa, the T or the U, they must apply for residency within 4 years. So they can apply between 3 and 4. So if somebody's like, oh, I got this visa, I don't know, I keep getting a work permit, and you see the expiration dates in 3 weeks, then they need to hurry on over to an immigration attorney to do the residency.
Yeah, because the T and U visa are not necessarily extendable. Once the 4 year, they will be issued a 4-year visa. By the end of the 3rd year, they can apply for a green card, but at the end of the 4 year, it's not extendable. So if they don't adjust status or don't apply to adjust status, they would lose it. So, the last one, look, 50,000 visas available to nationals from countries that have low rate of immigration to the United States recently. So the countries that will be eligible most likely will be countries from Africa and certain European countries. Nobody from North America, including Canada, Mexico, is eligible. Nobody from Central America is eligible, and only a few countries in South America is eligible. Citizenship, very quickly. We talked about the basic requirements. So you can become a U.S. citizen by blood. That is, you have ancestor, your parents, U.S. citizen, then you can derive citizenship if you are not born in the United States. If you're born in the United States, that is the jus soli. That is, doesn't matter what immigration status your parents are. If you're born in the United States, you are born U.S. citizen. Based on this very famous case, Wong Mark versus United States is a case from 2 centuries ago. Still good law, and people try to reverse it. And naturalization, you have to be a green card holder for 5 years, or if you are in marital union, that is for 3 years. That is, if you separated in 2 years and 9 months, get a divorce, you have to wait 5 years. You have to know English, speak, write, and listen, speak.
You also have to know some questions about the United States of America that I'm embarrassed to say that I don't know. Like I sit in USCIS sometimes and they have the questions going and I'm like, yeah, when was that battle fought? So they have to study for a civics exam, which Robert knows a lot about.
Yeah. What happened in 1865? Well, a lot of things happened in 1865. So questions like that, right? So I think we are really running out of time, but are we?
We are out of time.
If not, I can keep going.
We started about 10 minutes late, so
Awesome.
we can run into the break. We've added to the schedule a little bit.
Okay.
If anybody's like me, I have an hour and a half attention span, and it doesn't go beyond an hour and a half. So let us know if you've hit that wall. But we can wrap it up pretty quickly, I think. And
so there's also not everyone is immigrant, so there are a whole long list of non-immigrant visas that people could come to the United States temporarily under these non-immigrant visas. It basically goes from A to V, and A is diplomats. B is very common. People come in a tourist visa. They can fall out of status because they overstay their visa, or if they come in as foreign student, did not enroll in school full time, or work without authorization, they are in violation of their status. So that's how people can go from being documented as a non-immigrant visa holder to the other side, become undocumented because they lost their status. S visa is precious and is very little known visa. It's for people who are informants, assisting law enforcement on cartel. And I asked, why is it an S? Snitch. It's a snitch visa. There are only 200 available, and you cannot apply on your own. The law enforcement that you work with has to apply for you. So that is a very little known visa. And S visa actually does lead to lawful permanent resident at some point, but the law enforcement holds all the cards on who can become lawful permanent resident. So we also have people whose life is in limbo. Yes.
Oh, sorry, I'm pretty loud anyways.
Yeah. So one category of individuals that you might encounter are people who hold temporary protected status. Temporary means temporary. These are nationals from countries that, as a result of ongoing war, civil conflict, or environmental disasters like Hurricane Mitch, Hurricane some other person, or earthquake. And I think it's the Department of State, right? That would designate the nationals from that country who are in the United States, before a certain time to apply for this limbo temporary protected status. And it's usually issued for a 12 to 18-month period. And the Department of Homeland Security has to make a decision 60 days before the expiration to decide whether to continue or not. And these are the countries that are currently designated as temporary protected status. The one that has been around the longest is Nicaragua and Honduras. And those are terminating in the next few months to a year. So when the Department of Homeland Security decided to not extend the temporary protected status for a country, people will be given 12 to 18 months to wrap up their affairs and depart. And I have clients from Honduras come to ask, so what do I do now? I have a business, I have a house, I have children here. Do I sell all these things? Not the children. Do I sell? Do I sell my business and house now? What do I do? I have been here for 20 years. So that may be questions that you would encounter. Some of them might have been affected by Harvey, right? And they may bring up these issues. They may walk to your office asking about a business or housing issue, but they may have an immigration issue that underlying their problems.
So in the Harvey context in Houston, these are statistics that came from NPR, and I don't remember the exact number, but there's something like 400,000 Salvadoran TPS holders, and that decision to end TPS for Salvadorans is directly impact rebuilding efforts in Houston, and the amount of people who will be eligible or available to provide reconstruction services in the city. So it's going to directly impact Houston in a major way.
Yeah, and Haitians for the Miami area. And the other famous life in limbo, DACA, Deferred Action for Childhood Arrival. So this has been put in place since June 2012, so who is eligible, right? You have to be continuously present since before June 15, 2007, and is presently in the United States when you apply. Enter into the United States before you turn 16, and you cannot be older than 30 years old. That is, you haven't turned 31 as of June 15, 2007. And you are either currently in school, graduated from school, or honorably discharged from the Coast Guard or the military, or working on your GED. Not convicted of felony or serious misdemeanor, or have multiple misdemeanor. That is, you have to have good moral character and not a threat to national security. And what benefits do you get? If you are approved as DACA, you get work authorization for the 2-year duration of your deferred action. And with the approval, you can go apply for a social security number, and with that, you can also apply for a driver's license, which is hugely important for people to be able to work.
So one thing that you might see is people that had TPS for a long time, but were also DACA eligible but never applied because they had TPS.
Yeah.
So the question is, and that's very relevant right now to the court case that came out about 60 days ago, I believe, that whether people can apply for the first time right now. Everybody may remember in September of last year, the administration decided that DACA should end, and everybody had to apply that was expiring for that had DACA expiring for March, I think, of this year. Through litigation, that's been extended for renewals only, right? So you can renew currently right now. There's been no change in the renewals. But there are no first-time applicants, no initial applications accepted right now unless
the Department of Homeland Security actually responded, have a memo issue to justify why the rescission decision back in September was still lawful. And I believe this is pending before the DC District Court. And the court will have to decide July 24th whether the government has to accept new applications. So we are holding our breath, waiting for the decision to come out, hopefully the right way.
And the other thing about that is that gets into the urgency, right? If somebody, the law seems to be changing, the policies seem to be changing regularly and very quickly. So if somebody's eligible for DACA for a renewal, our office treats them as an urgent matter because you never know when and if that's going to change.
Yeah.
So they need immediate legal assistance.
Yeah. So we, at Catholic Charities, we have workshops, and people can register for the workshop every Thursday. And we've been doing like 12, 16, 20 applications every week because we don't know when this is going to end. So we want to help as many people apply as possible for renewal. So current changes, we kind of touch on it. Matter of Castrotom talk about the immigration judge's authority or discretion to administratively close cases. Matter of AB is about private action, domestic violence issue, gang violence. Funding is always a problem. And immigration is a system focusing on enforcement only, almost. So that is the challenge with living in the immigration world. So thank you, everyone. And,